Standing in for Augusta Yako, my name is Lillian Ogazi. It is a pleasure having you with us on Judiciary Watch. Today's discourse centers on pre-election legal issues.
Issues where a candidate who legally won the election is substituted by the party. Went to Supreme Court, and the recent one, if you remember the case of Mato against Hembe, where the Supreme Court declared that Hembe did not win the primary election, rather that it was Mato that won the primary election, nullified the election of Hembe, removed him from office, and ordered that he should return all the money he has collected from the National Assembly within 90 days.
Jacob USMAN Esquire is our guest today. Please stay tuned. We will be right back.
Keep watching Judiciary Watch for deep knowledge of the law,
issues bordering on our collective and individual fundamental rights,
for knowing the correct perspective of the law,
issues of governance.
You just watch Judiciary Watch,
because there's no program that is like it.
Justice John Soho of the Federal High Court sitting in Abuja has set aside his earlier judgment delivered on December 13, 2017, which directed the inauguration of Obiora Okonkwo as the lawful candidate for the vacant Anambra senatorial seat. Justice Soho set aside the judgment on the grounds that the plaintiff, Obiora, misled the court to get the consent judgment. The court, in addition to the terms of the judgment, also barred the People's Democratic Party from participating in the polls scheduled to hold on January 13, 2018.
It could be recalled that Justice Soho had on December 13, 2017 ordered the Independent National Electoral Commission to issue the certificate of return to Obiora Okonkwo as a valid candidate of the PDP Anambra Central Senatorial District. But in an application of variation, INEC asked the court to enable it to conduct another election in January 13, 2018. Delivering ruling on the application of variation brought by the election umpire, Justice Soho said that his judgment of December 13, 2017 is liable to be set aside because it was a consent judgment and was not based on merit. Soho added that in line with the doctrine of judicial precedence, the decision of the Court of Appeal which orders INEC to proceed with the election takes precedent. This implies that the People's Democratic Party has been barred in the Anambra Senatorial District polls scheduled to hold 13 January 2018. Emmanuel Bagudu, PTV News.
Justice Ahmed Mohammed of the Federal High Court sitting in Abuja has fixed January 15, 2018 to rule on an application seeking to nullify the authenticity of Atiku Bagudu as governor of Kebbi State. At the resumed hearing on Thursday, PTV's judiciary correspondent reports that the plaintiff, General Bello Sarkin Yaki, has appealed for the discontinuation of the case.
The case between General Bello Sarkinyaki and Kebbi State Governor Atiku Bagudu is the first pre-election matter to be heard in the Federal High Court headquarters Abuja in the year 2018. Counsel to Governor Bagudu, Ricky Tafa, told journalists that the plaintiffs were not in court to state clearly their grievances with the governor.
No, they allege that the sitting governor made a false declaration. It's an allegation. Whether they made it out or not is a different consideration. This is a matter for the court to determine. We are not convinced that there is any such thing, but it's for the court to determine that based on the evidence.
Sahabi Sani is a legal aid to the plaintiff, General Bello Sarkinyaki. He told journalists that his boss has withdrawn from the case because they discover it is baseless.
I am a true believer of truth and justice. When you look at the pleadings, you look at the charges, you cannot find a single evidence that will prove to you that the governor of Kebbi State, whom they say was indicted or convicted, you can never see anywhere in any record, any part of the world. I'm a lawyer by profession. I'm conversant with the processes of the law. I have read widely, very widely. In fact, I was even more serious with the major contender, who is not even on ground, General Bello Sarkinyaki, about the case. When I finally realized it was just an academic exercise, no evidence, only a blackmail, a vindictiveness, particularly The party thought the only way they can victimize the president is by trying to destroy the integrity of the Kebbi State Governor, based on the recommendation he made on the 1st October on the issue of his agricultural reform. Every Nigerian must be aware that Mr. President was very specific of Kebbi State, and they have seen the relationship of the governor with the president. That was all, nothing other than that.
The matter continues on January 15, 2018. Emmanuel Bagudu, PTV News.
Hundreds of supporters of Osun State Governor Rauf Aregbesola thronged the premises of the Federal High Court Abuja to protest the resistance of some aggrieved citizens of the state who dragged the governor to court for allegedly creating additional 36 local council development areas to the existing 30 local government areas in the state. Counsel to the plaintiff, Robert Clark, brought an application seeking the order of the court to nullify the 36 LCDAs created by Aregbesola in March 2016.
These people who claim to be supporters of Governor Rauf Aregbesola of Osun State believe there is nothing wrong in the creation of 36 local council development areas in Osun State. At the hearing of the matter on Thursday, counsel to the plaintiff, Robert Clark, told the court and journalists that Governor Aregbesola's creation of 36 LCDAs in Osun State is unconstitutional. He therefore sought the order of the court to nullify this action, which took place in March 2016.
We have come to court to say that the Osun government are operating illegal government by allowing these local councils to be operating. The Constitution approves certain local governments, and the local governments they want to hold election in are not approved by the Constitution. So we are challenging their right to be operating illegal local governments. Secondly, we are challenging the right that the governor will take money from the appropriated money and use it for unappropriated money. Because payment of salaries to these councils amount to paying illegal councils without any appropriation of the money by the National Assembly. So that's why we are in court. We are not here for election, we are not politicians. We are saying you are operating illegal local governments and you are spending money to operate them without appropriation, which is contrary to the provision. That's why we are here.
For counsel to Aregbesola, who is Osun State Attorney General Ajibola Bashiru, the governor is in the right track, and even the Federal High Court lacks jurisdictional power to hear the matter.
The court had become functus officio and has no jurisdiction to grant the order. We have also challenged the substantive suit on the basis of notice of plenary objection, saying the Federal High Court does not have subject matter jurisdiction, and also that the plaintiff has no local standing. They are just busy body. And the court today came and several applications came before the court. The court decided to take applications to regularize the position of the parties, which were duly granted, having been considered to by the plaintiffs. Then the court went to consider two applications by the Osun government, which is one, that the motion ex parte orders granted by the court on the 4th of December should be discharged.
After taking argument from both counsels, Presiding Judge John Soho reserved judgment in a date to be communicated to both counsels.
It's time for a short break. When we return, our discuss segment is next.
You just watch Judiciary Watch.
Because it's no program that is like it.
As the name implies, pre-election means things done before election. And what are the things done before the election? Party primaries, nomination of candidates, substitution of candidates, withdrawal of candidates. These are all pre-election. Because election in law is the election proper, the act of voting for your candidate. That is the election. So any issues before you cast your vote is called pre-election. Nomination, sponsorship, substitution, withdrawal of candidates are all pre-election issues, and the jurisdiction to hear them are exclusively vested in the Federal High Court, the High Court of a state, or the High Court of Federal Capital Territory by virtue of Section 87, Sub 9 of the Electoral Act 2010 as amended. If you remember the case of Mato against Hembe, where the Supreme Court declared that Hembe did not win the primary election, rather that it was Mato that won the primary election, nullified the election of Hembe, removed him from office, and ordered that he should return all the money he has collected from the National Assembly within 90 days. This Supreme Court did to serve as deterrent to political parties from their gangsterism and political godfatherism and illegalities committed and perpetrated by parties in conjunction with candidates who have the big envelopes to offer. You see, the problem we have is in Nigeria, we don't have mechanism to resolve inter-party matters through arbitration. I've been involved in a committee set up by INEC, and that is one of our recommendations, to look at inter-party issues. Can it be resolved through arbitration, through mediation, through conciliation? And Nigeria now, we are trying to imbibe that culture of resolving this issue without necessarily going to court. Until that is done, for now, what we have is going to court straight ahead, because we discovered that in Nigeria, a loser of an election hardly agree that he lost the election. And so where he is dissatisfied with the outcome of the primary election, although the party has outlined internal mechanism to be used before you go to court, some of them don't utilize such mechanism, but they go straight to court. Now, what are these mechanisms? By the constitution and guidelines of the political parties, where you are dissatisfied with the outcome of a primary election, you appeal to the appeal panel. When the appeal panel sits and decide, the appeal panel will submit its report to the National Working Committee of the party, which has the final say. Now, when the appeal panel sits and arrive at its decision, either allowing your petition or dismissing your petition, then if you are still dissatisfied with the outcome, you have a right to go to court. And that is why under Section 87 sub 7 of the Electoral Act, it gives the Federal High Court, the State High Court, the High Court of FCT exclusive jurisdiction to entertain matters that arise from primary election of political parties. Inter-party issues are issues within the same party. When you say intra, is within the same person or within the same party. So inter-party issues are issues that arise within the party. And what are these issues? Some of them are issue of nomination, issue of sponsorship, issue of withdrawal of candidates, are all intra-party issue. It's intra because it is between two members of the same party. And these issues are issues that, as earlier stated, are decided by the Federal High Court, High Court of the State, High Court of FCT, by virtue of Section 87(9). And by that provision, the matter goes from Federal High Court of FCT High Court or High Court of the State and go up to the Supreme Court. Unlike the election petition, where apart from the governorship and the presidential, the legislative election stop at the Court of Appeal. Sometimes disputes arise between political parties and INEC. Most times, these issues are resolved internally. The political parties meet with INEC, set up a committee, look at the issues and arrive at a conclusion. Sometimes there are issues that cannot be resolved by a committee or through a committee. In such a situation, the political party has a right to go straight to court and seek for redress. For instance, in the case of Labour Party against INEC, where Labour Party challenged the provision of Section 140, subsection 1 and Section 141 of the Electoral Act, which provided that a court shall not declare anybody as the winner of the election who has not participated in all the stages of election. Labour Party was dissatisfied with that provision of the Electoral Act and approached the Federal High Court. And I remember vividly, His Lordship Justice Kolawole struck down those provisions and held that where a court or tribunal held that a person who is purported to have won the election did not in actual sense won that election, they nullify his election and then return the person who is deemed to have won the election. So that is one of the instances. Also, there's a case of Fresh Party against INEC where the party went to challenge the decision of INEC. There are a lot of decisions that where political parties are dissatisfied with the stipulations, with the guidelines of INEC, they have the right to challenge and seek redress. And of course, the court has in so many instances. You see, the Anambra conundrum is a serious matter that any lawyer who wants to comment on it has to be careful. Why did I say so? It's an issue that commenced in 2014 after the PDP primary election, where Uche Kunife was declared as the winner of the election. She was sponsored by PDP, but in the tribunal, she was challenged in the tribunal by APGA, and the Court of Appeal held that she was not the winner of the primary of the election that produced her. Therefore, her nomination and sponsorship was put in question and nullified. And then the court ordered that INEC should conduct fresh election within 90 days. But the problem here is this: why they were in tribunal, Ekunife's opponent in the primary, Okoronko, went to Federal High Court to challenge the nomination of Ekunife. Now, while this matter was pending before Honorable Justice Soho, I understand that all the defendants in that matter who had earlier filed counter affidavits and objections, written addresses, all withdrew their processes. Therefore, what was left before Justice Soho was just the originating summons. And in the absence of any counter affidavit, of course, His Lordship was right when he allowed the originating summons, granted the relief sought by the plaintiffs, and ordered that he should be sworn in by INEC. Now, the difference between that case and the one that went to Court of Appeal through Election Tribunal is this: Court of Appeal nullified the election of Uche Kunife on the ground that she was not validly nominated by PDP. The judgment of Justice Soho is that Okonkwo was the winner of the primary of election and ought to have been declared, ought to have been sponsored. And since that election was won by PDP, he should be sworn in. There's a little dilemma there. Only the court can resolve that matter, and not I. I don't have the bias, the competence, and what it takes to resolve that matter. So I think the best thing to do is for them to go to the appellate courts. They are numerous. 1. Section 88 of the Electoral Act forbid a party from getting the funds from outside Nigeria. If a party goes outside Nigeria to source for funds, it's an offense under the Electoral Act. If the party gets a fund from outside the country and retain that funds, also it's also an offense under the Electoral Act. And what is the punishment? If that party is liable, 500,000 naira fine is the punishment. What this means is this: don't go outside the source of Nigeria to source for money for politicking. Any money that must be used for election, for your politics, must be sourced for within Nigeria. And the reason is very simple. It safeguards our political system from external influence. Of course, it is said that he that pays the piper dictates the tune. So if a foreigner, if another country sponsor or funds a political activities in Nigeria, don't be surprised when they come in to have a say in Nigeria. So that is why Electoral Act forbids such funds. Again, Section 23 of the Electoral Act forbids buying of voters' card, selling of voters' card, attempt to sell voters' card, being in unlawful possession of voters' card. All these are offenses that if you are found guilty, punishment is 500,000 naira or imprisonment for 2 years or both. Why did the Electoral Act make this provision? Or why did our legislators make this provision? You go to some places, you see a politician buying cards, buying voters' card, piling voters' card, awaiting proper election. So it is now an offense for you to buy, for you to sell, or for you to even make an attempt to sell, or being in unlawful possession of voters' card. So if I am in possession of your voters' card and I'm caught and I don't have reasonable reason for it, or I don't have your permission to hold your voters' card for you at that time, I'm guilty of an offense and I'm liable to be sent to prison for 2 years or payment of fine of 500,000 or even both. Another offense is double nomination. Under Section 32 of the Electoral Act, it forbids a person from nominating a candidate, 2 candidates for the same office. What does this mean? I want to nominate you as a candidate for FCT Senate. I'll also go ahead to nominate Mr. B. For instance, nominate Emmanuel for FCT Senate, the same office. I, the nominator, the law say I have committed an offense, and if I'm found guilty, I'm liable to imprisonment of 3 months or a fine of 100,000 naira or even both. Now, under Section 31, subsection 5 of the Electoral Act, it said where a political party, where a candidate gives false information about himself, once it is found that those informations are false, he will be disqualified. Under 31(8) of the Electoral Act, a political party that sponsored a candidate knowing fully well that he is not qualified is liable to a fine of 500,000 naira. So these are some of electoral offenses. This precedes the election. 2019 is fast approaching. 2018 is a prelude to 2019. This is when the real politicking starts. My advice to voters is that use your PVC wisely. Your PVC is your power. Gone are the days where politicians hijack electoral materials and stuff ballot papers. Today, we are in the E-Day, the electronic voting day, where voting is done by the use of your PVC and the card reader. Hold your PVC, guide your PVC jealously. Don't sell your PVC. If you sell your card, you have sold your rights. You have sold your destiny. As for me, I go with my PVC, and I guide it jealously, because it is the only way we can tame irresponsible politicians. There are some politicians, the moment they are elected into the National Assembly, they remain in Abuja. The next time they go back to their constituency is during election. Time has come for us to show them the power in the electorate, and that power is proper use of your voter's card.
This is where we draw the curtain today on Judiciary Watch. Don't forget to send us your comments and contributions to our email and social media platforms on your screen. Until then, stay law-abiding.